So today's webinar is Beyond H2A, Permanent Foreign Labor Options in Agriculture. And our presenter today needs no introduction, but I'll give one anyway. LJ Dorigo is partner and co-leader of the immigration practice at Harris Beach PPLC, where he specializes in corporate and professional immigration involving the full suite of employment-based immigration, including H visas, as well as all family-based immigration processes. LJ is no stranger to agriculture. He's presented at several of our webinars in the past, and he's certainly an expert in many temporary as well as permanent immigration options for agriculture businesses, farming, fishing, and forestry in the Northeast. Before we begin, also, I'd like to give a special shout out to the New York Farm Bureau, who is co-sponsoring this webinar with us. We appreciate their assistance in coordinating this webinar and co-sponsoring it for you today. So with no further ado, I'll turn it over to LJ.
Okay, well, thank you all for participating today. So as we all know, one of the biggest challenges in agriculture is finding labor to fill both seasonal as well as permanent positions. Now, the H2A program has helped to relieve some of the strain, but many positions fall through the cracks. Specifically, our dairy farms who can't file for milkers, for example. Further, some farms need year-round labor that fall outside of the H2A program. There have always been green card categories available for lower skilled positions, but they weren't always compatible with the H2A visa programs since they were so backlogged. So what this meant was it could be 3 years or more before someone would be able to enter the U.S. on a green card to work for these positions. And this is a problem because once certain stages of the green card were filed, workers could no longer enter the U.S. on H2A visas. So a lot of employers just didn't bother filing because, you know, they can't do without the seasonal workers by waiting for a green card to be issued. So it just was very underutilized. For the past couple of years, however, that backlog of pending green card cases has pretty much cleared. So we don't see the same backlogs that appeared even 2 years ago, where someone would be waiting 4 to 5, 6 years to get a green card. So it really has been a game changer that this is now an available option, and a lot of farms don't know that this even exists. So one of the reasons we're doing this today is to provide a little bit of education about the options that are out there. So today we're going to review the process, the procedures, and basically break down how it all works. So just a quick overview. So clearly the need for reliable labor is not being met currently, and it seems the U.S. government is conflicted about whether or not there are U.S. workers available. The thinking or philosophy is that there are plenty of U.S. workers to fill these jobs, so why would we ever let workers come in either on an H2 visa or on a green card? And that's sort of the mentality that we're working with right now. There's been a patchwork of prior programs, H2A, H2B, but this doesn't really seem to solve the problem that we're experiencing every day. The H2A program serves 7,700 ag employers, and it fills over 140,000 of all farming positions. So it's a significant program. It's also estimated that half of the 1.2 million farming positions are actually filled by illegal workers. And, you know, although for many years farms were able to sort of navigate that, but the reality is hiring workers under this current system is really risky. We are living under a culture of unprecedented enforcement, and especially during the past couple of years, even over the past year, there's been a 300% increase in I-9 audits and worksite enforcements. So right now, it's really a matter of time before you're going to get a visit from ICE to do an I-9 audit, and that's where things tend to unravel. So, you know, the problem is there's increasing ICE enforcement activity, including raids. There's interruption in your business if there's an ICE raid, and also just the fear among your workers. Fearing that ICE is going to come, and if there's any indication that that's going to happen, a lot of times they're just going to take off and you won't see them again. The other thing we're seeing very recently since March is the reintroduction of the Social Security Administration no-match letter. So this is also creating very significant issues in bringing to the forefront that some of the workers may be undocumented on your payroll, or maybe the documents that they submitted are not valid. So these are all issues that come into play with not only finding a temporary solution, but also permanent solutions. So some of the benefits of green card sponsorship would be that really any position qualifies. It's not limited to agriculture or farm work. Any single position that an employer files for does qualify for a green card. Dairy farms can actually file for milking positions and don't have to necessarily characterize it as crop related like we have to do for H2A, since this is all year-round employment. There's also flexibility in developing job descriptions. You can combine cropping duties with ag equipment operation and even milking. So H2A, it's very specific, very defined. We have to make sure that it falls in to a seasonal period of need. It's got to be tied to a crop. It's got to be tied to a growing season. The green card, none of that comes into play. The only thing we have to do is show that it's a year-round need, so we can't focus only on crop, but we want to tie in other duties which sort of transcend that whole seasonal arena. Also, if timed carefully, you can continue to bring in your workers on H2A and H2B until the last stage of the green card process is filed. Once that happens, they're basically in a different status. So they're in what we call a green card applicant status or adjustment of status applicant. That's an independent status that is available to them outside of the H2A program. So the idea behind this is to bring them in on H2A until they reach a certain stage of the process where they can stay independently. And that's the goal of the process, is to sort of reduce your reliance maybe on some of the challenges of the H2A program to the extent that you can. So this slide is basically a macro overview of what this process looks like. So there are essentially 3 stages to the green card process, and we start with the labor certification. So this is basically an H2A program on steroids. It follows a similar trajectory, similar requirements, but it's just on a much larger scale. So the first thing that we do for the green card process is we are working with Department of Labor to identify a position that's seasonal. So similar to what you do with the H2A, for those of you that participate in that, or even H2B, you're coming up with a job description, you're defining requirements. There is a prevailing wage requirement, which means that like for H2A, we're used to the adverse effect wage rate, which is a state rate. For H2Bs, we are used to this prevailing wage requirement where there'll be a wage that's arrived at by the U.S. Department of Labor based on the position, qualifications, the location of employment. So this is a similar idea. It's a form that's submitted with Department of Labor. It lists the location of employment, the job description, and the requirements. Department of Labor is going to come back in approximately 4 to 6 months and tell us what the required wage rate will be. And we're going to look at that a little more closely later, and I'll give you some examples of what the wages look like. It's unlike H2A and H2B, it's a 4-tier wage level from level 1 to a level 4. So in many cases, the rate that's required for a green card is going to be less than it is for H2A and H2B, just because we're able to get a level 1 wage in many cases. So Department of Labor, at that stage, we also do advertising. So the advertising is a little different from H2A and H2B in that the only ads that we need to place would be 2 Sunday newspaper ads, and then there's an ad that runs on the New York State Job Bank or Connecticut or wherever state you're in, it would run in that job bank. So after all that recruitment's done, then the goal of the recruitment is to determine whether there are any qualified U.S. workers for the position or not, because that is the threshold question. In order to proceed with the green card, we have to first show that you were unable to find any U.S. workers for that position. And quite honestly, it's probably not going to be that difficult to do. We run into this all the time with H2A and H2B. The problem is we're doing this because we can't find U.S. workers that want to do this type of labor. So after Department of Labor finishes their processing, then we move on to 2 applications that get filed with U.S. Citizenship and Immigration Service. And that would be an immigrant visa petition, which is stage 2 on a form I-140. So that's a petition that's filed, basically tells immigration that, all right, we've got this labor certification. Department of Labor has agreed with us that we can't find any qualified U.S. workers. So we're seeking an immigrant visa to bring in workers from outside the U.S. So there are application forms. There's a support letter that an employer signs off on. And then that gets filed with U.S. Citizenship and Immigration. At the same time, there's an adjustment of status application. So this is a separate application that seeks to change your worker's status. Maybe they're here on H2A or H2B. We're seeking to adjust their status from that temporary seasonal status to permanent resident, to a green card, to an immigrant visa. All of those are interchangeable, for meaning that somebody's able to live and work here without restriction. So in most cases, those last two stages, so the I-140 and the I-45, are filed together in one package with immigration. We call them three separate stages because they're separate applications, but those last two are filed together. Now, once those applications are filed, specifically the last application, the adjustment of status, once that gets filed with the Immigration Service, the workers are then in a different status, or they have dual status. So if anybody in the U.S. has a pending green card application or a pending adjustment of status, that allows them to stay here independently of any other visa. So although they may have entered in on an H2 visa, once this is filed, they basically, if they still have validity left on the H2, they also have this pending green card. Now, once the H2 visa expires, well, then they're still able to stay because they've got this pending green card in process. So it basically undoes the need at some point for H2A. With this application, these last two stages, an employer can also file an application for employment authorization. So just because they're filing a green card, they're entitled to a work permit. The work permits are issued in 1-year increments, and they can be renewed every year until the green card is approved. So again, at that point, they can stay permanently. Once this application is filed, they're legally able to stay in the U.S. even past the expiration of their H2 visa. They can also apply for the work permit through this. So they're going to have work permit and the ability to stay here for the rest of the process, which honestly can take up to 2 years in total. But after that first stage, they're able to stay here. So, that makes a huge difference in that, and at some point they can travel back and forth while this is in process, and then they'll be scheduled for an interview ultimately, which we'll talk about. Now, this isn't limited to people that are in the U.S. So even if a worker has never been here before, or maybe they were here on an H2A visa in the past and then went home and they haven't been back in a while, well, you can still go through this process for them. They don't have to be here. It's just done a little differently, and that's done through consular process. So what that means is we do the same thing for the labor certification, stage 1. We do the same thing for the visa petition form I-140, but once the I-140 is approved, instead of moving to the adjustment of status here, we default over to consular processing. So what that means is Immigration Service approves the I-140. They will then notify the U.S. consulate in the worker's home country that this petition was approved. That then triggers the consulate through a middle agency called the National Visa Center, which works with the U.S. consulates abroad to kind of schedule interviews at the embassy, to accept paperwork. So after the I-140 is approved, then the process shifts to consular processing, and eventually the worker will be scheduled for an interview, and they'll get their green card at the consulate in their home country, and then they can enter in. But again, the only challenge with that is it can take up to 2 years before the worker's actually able to come in. So the reason why sometimes it may be a little more beneficial to do it, to bring them in on H2A first, is that you're minimizing and sort of mitigating that duration of time that they're going to be outside the U.S., because you'll be able to employ them on H2A and then kind of work on the green card as they're already here. All right, so just a quick summary of the costs for the green card process. So again, there's three stages of the green card process. So for the first stage with Department of Labor, the Perm Labor Certification, there's no filing fee currently for that. So there's nothing that you have to pay. And also, just so you know, the only part of this process that has to be paid for by the employer is the perm labor certification. So that means the advertising costs, you can't charge that back to a worker, or legal fees. So if you're having an agent or attorney prepare this for you, you have to pay that. You can't charge it back to the worker. Now, for the later two stages, so the I-140 immigrant visa petition, which is stage 2, there's a government filing fee of $700 per worker. Also, you can request premium processing of that petition. So normally it can take 6 to 8 months, but they will do it in 15 days if you pay them $1,410. So in my opinion, sometimes it's worth paying that because it accelerates the overall period of time that it takes to get the green card. Because ultimately the workers will be scheduled for an interview at the local immigration office wherever they're living. And it just accelerates when that interview is scheduled by paying that fee. And the last stage, the I-45 application, there's a government filing fee of $1,225. Now that does also include an application for a work permit and travel document so that they can work and travel throughout the green card process. Again, that doesn't have to, that can be paid by the employee, and none of this includes preparation fees and legal fees for preparing it. These are just the government filing fee costs. The challenge sometimes, even if you're having the workers pay, is the workers may not have all of this money up front. So they may need the employer to front the cost, and then you can do, you can just have a payment plan with them to pay you back if they don't have the money. The other thing is what a lot of firms do is, in order to sort of protect your investment in this process, the reality is once a worker gets their green card, they can go to the farm next door and begin working. By law, there's no time period by which they have to be tied to you. So workers are portable. So in order to protect your investment, a lot of farms will do sort of a reimbursement agreement with the worker, saying that if we agree to pay the cost of your green card, you have to promise us and agree that you're going to stay with us for, let's say 3 to 5 years from the time they get their green card, so that at least you'll be able to realize some of that investment you've made in them. And in many cases, they're just going to stay anyway because the fact that you were willing to sponsor them for this when a lot of people maybe necessarily weren't. There's a level of loyalty that goes in. And the other thing is you want to think about who you're sponsoring a green card. So you've probably got workers that have been coming to work for you for years and years and years. They're like family. Those are the people that really you want to make the investment in because they've already demonstrated themselves. So just some of the basics here. So this is an application by the employer to U.S. Department of Labor to certify the individual and position after a mandated recruitment campaign. Nearly all positions qualify. The process does require significant employment involvement, including the payment of legal fees for the DOL phase. So some of the strategies to navigate around the H2A, because in reality, those of you that do participate in the H2A or H2B program, you rely on these people to come in every season. So you don't want to necessarily do anything that is going to jeopardize that. Now, the reason why it's even an issue is because for an H2A, we're demonstrating to the government that it's seasonal, temporary employment, not year-round. So in order to get a visa at the consulate, these workers have to demonstrate that they don't have the intent to stay permanently in the U.S., that they have a residence at home, that they're only coming in for the season, and then they're going to go back. That's for all non-immigrant visas. You can't have the intent to stay permanently. Obviously, once a green card's filed, well, then that's pretty good evidence that they intend to stay permanently. So the process at the Department of Labor stage is not considered really to be a green card application by the employee at that point, because it's really all about you as the employer. It's not until the second and third stages of the green card process are filed with immigration that becomes attributable to the foreign worker. And that could impact their ability to come in on an H2 if the consulate knows that they have this in process. So that's why I say timing is important. So obviously, we all know H2A is seasonal and temporary. The perm, the green card, is year-round permanent employment. So in the green card application, we want to distinguish the H2A position from the year-round position. And it's really not that difficult to do because there's so much flexibility in defining the job duties. So you can certainly include your H2A work, but also add in maybe winter maintenance work. A lot of times we'll do H2A programs for crop workers and winter maintenance grounds workers. So you can combine those. You can, for dairy farms, you can file as a farm worker crop for H2A, but then you can file like a farm worker animal caretaker or milker for the green card. You can have as many different positions as you want. You can have barn supervisors or ag supervisors under this program. So the sky's the limit with the number of positions you can file. The other thing is you can have multiple workers. So if you need, let's say you need 20 milkers, well, you can include them all on the one labor, well, on the advertising anyway, you can include all of them on a single advertisement. You do have to file separate application forms with Department of Labor, but a lot of the information can be combined. So it does make sense if you're doing this. It may make sense from a cost perspective to do multiple positions. So the timeline with H2A, all right, so you can begin this process while the workers are outside the U.S. or when they come in. A lot of times we do these while the worker's out because there's a lot of preparatory work that has to be done before the official filing, and you know, specifically the prevailing wage determination. So the prevailing wage determination doesn't require any information about the worker. We don't need to name them, and that does take, it can take 4 months to get that through. So that's a good thing to get done while they're outside the U.S., knowing that we're going to have that 4-month ramp-up period. And all we need for that is the job description and the location of employment. So very simple. Workers can enter, again, workers can enter on the H2A program throughout the DOL stage of filing. So in total, you could be looking at 8 to 12 months for that stage by the time you factor in how long it takes to get the prevailing wage determination back and how long just the general processing takes for the DOL application. Once the Department of Labor phase is approved, which is, again, the perm labor certification, workers should enter the U.S. on H2A or H2B before filing stage 2 and 3. Because again, when we file stage 2 and 3 of the green card, they're telling the government that we intend to stay permanently. That's incompatible with H2. So we want to make sure that, you know, if you do participate in the H2 program, that we time it so that we're not doing anything until the workers come in, and then we have to wait 90 days. And the reason why we have to wait 90 days is because there's a rule that's applied by Department of State that says if any worker comes in on one of these temporary visas and then files a green card application, well, they can attribute fraud to them, knowing, you know, with the saying that they intended to come in on this temporary visa and intended to stay permanently. But by waiting 90 days, the government has said that that presumption disappears and it's not an issue anymore. They cannot deny an application for a green card, or they can't accuse them of committing fraud if they wait 90 days, because that's a reasonable amount of time for somebody to change their mind. So we wait the 90 days, and after that happens, then you know, the stage 2 and stage 3 of the green card process are filed with U.S. Citizenship and Immigration, along with an application for employment authorization and travel authorization. Once USCIS receives that application, they're locked in. They can stay here. You know, they'll still have H2A status for the rest of the season, but say your H2A program ends November. Well, after November, they can still stay here because they've got this pending green card application, and they can actually stay here until the green card's approved. They don't have to leave at all. If they want to leave, they can. Once the travel permit is issued as part of this application, that normally takes 90 days or so, maybe 4 months from when the last stage of the green card's filed. They'll get their work permit and their travel document. So then they can travel, come back and forth as much as they want. You can continue to employ them in any capacity that you want, because it's not tied to a particular position like H2A anymore. So the timeline without the H2A program, so say that you have no interest in participating in H2A or H2B. Well, again, you can still do this while the workers are outside the US. So that works as follows. So you're going to identify the workers that you want to sponsor that are outside the US. Maybe they've been here before. Maybe they've worked for you before. The only caution that we want to have is that we want to kind of explore the worker's background. So if a worker was here illegally, and you may not even know that, so that's why it's important to explore and really have an honest conversation with the employer or the recruiter that you're using, because if there's a record that the worker was here outside the US, they're basically going to be denied their green card. They would need a waiver, which is much more complicated to get for a green card than it is for a non-immigrant H2A visa. So you want to make sure that they have no prior status violations, that there's no record that they were here illegally, and then process those workers. So the workers are going to remain outside the US for the duration of the green card process, which can be 1.5 to 2 years. They won't be able to come in on any visa while that's in process, because again, they've already demonstrated immigrant intent, so therefore they're not eligible for H2, and they would just stay there until they have their interview at the consulate and enter that way. So once Department of Labor and USCIS approve the application, the workers will process their immigrant visas at the U.S. consulate in their home country. So this, there's a whole process that they go through with the National Visa Center. They submit paperwork, their forms, to the National Visa Center, who then forwards everything to the consulate. Consulate schedules an interview. They issue in their passport, they get an immigrant visa stamp. So that allows them to come in. Once they get here, they'll be mailed their green cards. By the way, green cards are issued for 10 years. So they'll have a card that's valid for 10 years, but just because it says 10 years on it doesn't mean the status expires. The green card status never expires, just the card does. And the only reason it does is because they want to make sure that they have the current biometrics, current photo on the card for the worker. So they just want them to get an updated card and run a background check on them, every 10 years. But a lot of times they never have to renew it, because once a worker's here on a green card, they can file for U.S. citizenship after 5 years. And most of them are going to do that. There's really, again, the only difference between having a green card and being a U.S. citizen, one is that you can't vote in an election and you can't run for public office. And if they happen to commit a crime, they'll be deported instead of put in jail like we would. But really, those are the only differences. A lot of people confuse citizenship with green card status or permanent resident status, but there is a distinction. And they're not eligible for the last stage of citizenship until they've had a green card for 5 years. And at that point, it's as if they were born here. All right, so backing up a little bit, I want to talk a little bit more in detail about the actual process and the steps. All right, so back to phase 1. Here we are at Department of Labor again. So again, once a decision to pursue a green card is made by you, the process includes the following. So you as the employer will register with the U.S. Department of Labor right on their website, and you'll get login information. They'll verify your existence, and then if you're using an agent to do this for you, you'd set up a sub account for us. We'd get a password, and then we prepare everything for you online. You then identify the positions you want. So if you want one position, you formulate the description, what you want the requirements to be. There are some limitations with what you can require for experience, because Department of Labor has pretty much already determined how much experience you can ask for various positions, like a farm worker. So generally for farm workers, we may be able to get away with 3 months experience, but probably no more than that. If you're doing an ag supervisor, you can get away with more experience. So it really depends on that, and we do an analysis once you identify what positions you want. We then submit a prevailing wage determination with the U.S. Department of Labor, which again takes 3 to 4 months to get back. The wage that will be issued is based on a 4-tier wage level, which is based on the county of the state. It's not a statewide wage like it is for H2A under the adverse effect wage rate. Therefore, a lot of times, if you're on the lower end of the experience requirement, you could get away with a level 1 wage, which is in some cases lower than what you would be paying under H2A and H2B. After that comes back, you're going to place a job order with your local Department of Labor, which is going to run for 30 days. You're also going to place 2 Sunday newspaper ads in your local paper. A recruitment report will be prepared highlighting where you advertised, how many workers you applied for the role, and whether or not you hired any of them. The actual DOL application form is then prepared and submitted after waiting a 30-day period from your last advertisement. And then you're just organizing your records and of recruitment in your audit file. Department of Labor will review the application, and then they will either approve it, they'll issue a notice of audit, or they'll deny it. For an audit, it's not like you've seen, maybe for the H2B program where it's super onerous. All they want to see is copies of the advertisement, your recruitment report summarizing your recruitment and who applied, and any resumes that you've received. And so it's a pretty, easy process to respond to. If you do have an H2 program, they may ask for information about how the green card position is different from your H2A position and whether or not, and how it's permanent and not seasonal. And so it's just basically explaining to them that, yes, you still may be using the H2 program for your seasonal role, but you also have these permanent year-round positions that you need to fill in addition to your seasonal roles. So it's basically just explaining that to them. For registering with DOL, it's a fairly simple process. You just do it online. Some of the information you need to do that with your company name, address, phone number, your employer identification number, and the NAICS industry code for your business. If for some reason they're unable to verify the company information, then they'll send an email to you asking for certain documentations like your business formation documents, articles of incorporation, state registration, business license, utility bills showing or tax bills showing that you operate at the address listed on the registration form. Once the account is established, you're going to get login information and a password to access the system where you're filing your application. You also can set up a sub-account for your representative so they can act on your behalf and submit applications. All right, so back to the prevailing wage. This is a snapshot of what appears in the Department of Labor online wage library. So this is what is used to determine what your wages will be. This is publicly available. The website link is on this slide, flcdatacenter.com. I just did an example for a farm worker animal. So this would be, for, let's say, a farm that needs workers to help care for animals, to do, even milking would fall under here, caring for baby cows, anything like that, chicken farms, anything like this would fall under here. So you're going to see we have levels 1 through 4. So if there's a level 1, and this would be maybe the minimum requirement. So we would do like a 1-month experience or 3 months. You'd probably have and this is for the Buffalo area as an example. So you'd be looking at $9.97 an hour. Well, that's quite a bit less than what you'd be paying for H2A, which is going to be $13.25 in New York. So, and you have direct control over what this is based on what your experience requirement is. But the most expensive that this could be, so the highest wage that you'd have to pay is $15.59 an hour. And that would be requiring the maximum amount of experience. So again, you can play around with it and see, how to get a wage level that falls within your pay scale. So here's an example of maybe an ag supervisor role. So first line supervisors of farming, fishing, and forestry. This is Albany, New York area. So for an example, a level 1 is going to be much higher because these are supervisory positions. So you'd be looking at $18.83 an hour, for a level 1. However, if you're requiring more experience than Department of Labor thinks is acceptable, then it just goes up from there. Basic rule is that the foreign national needs to be qualified for the position. So normally you cannot use, so if they're currently working for you on an H2A, you can't use that experience to qualify them for the green card position if you're filing the green card and for the same position as the H2A. The only time you can include same employer experience is if they worked for you in a different role. So say that they've been working for you as a farm worker, crop, and the green card position is under a different position. Maybe you're going to be doing farm worker, animal caretaker, or maybe they're going to be doing milking duties. Well, that position is going to be 50% different than what they were doing under the crop position. So you could use all of that farm work experience they gained with you. So that's sort of how that all works. Same thing, if they've been working for you as a farm worker and you're filing a green card under a supervisor or foreman role, well, then they can use all of that experience that they gained with you. Otherwise, the experience would have to have been gained by employers before you. Doesn't have to be in the U.S., could have been work in Mexico or any other country. You just want to, as you define the position requirements, you just want to make sure that the workers you want to sponsor are able to demonstrate that they have that experience. And immigration will require letters from their former employers confirming experience. So the basic steps for recruitment for non-professional positions. So again, we already talked about the prevailing wage requirement. So the employer, you have to submit a job order with the State Department of Labor. That runs for 30 days. Every state has their own job bank. You also have to place 2 Sunday newspaper advertisements. These ads have to include your name, location, and a description of the position. You don't need to put the wage in the ad, and you shouldn't. They can be on consecutive Sundays, or they don't have to be. But they must fall between 30 and 180 days prior to submission of the application. Also, you have to file the application before the ads reach 6 months old. Any ad that is more than 6 months old, you'd have to re-advertise. There's also an internal posting requirement, which we call a notice of filing. So this is just a posting notice that you're going to display at the location of employment. And that's going to be posted for 10 business days. Basically advises your current workers of the open positions, and that if there's any complaints that there's information for U.S. Department of Labor that they can contact. All right, some practice pointers for recruitment. So the standard of review for these types of positions is minimally qualified. So that means if any U.S. worker applies for your position and they have 1 month experience, you can't disqualify them. So you have to, and also the workers that you want to sponsor, you need to make sure that they have that experience. So it's a minimally qualified standard. It's not, even if the foreign worker you're sponsoring has more experience and is more qualified than a U.S. worker, it doesn't matter. You have to accept anybody that minimally meets the requirements. You should never have the foreign national employer review resumes. You as the employer are not required to inform a U.S. worker why he or she was not qualified. You may disqualify an applicant for only lawful, objective, business-related reasons, not for unstated requirements or duties. Employer is not required to contact a U.S. worker who is facially unqualified. So if they fill out an application or they send you a resume and you're requiring farm work experience and they have none, they're a school teacher, well, you don't have to consider them further or even contact them. You have a limited ability to disqualify for soft reasons. So say they have terrible hygiene, or they're just non-professional, or there's something not right about them, or they have high employment turnover, that sort of thing. So you can factor some of that in. You should consider applicants who could be trained to perform duties within a reasonable period of time based on the occupation. Before completing the application, ensure that the recruitment report prepared includes details on how and when applicants were contacted and the reasons why U.S. workers were rejected. You also need to maintain all resumes and documentation of contact with applicants in your file. I'm going to move a little more quickly through the rest of these slides so we save time for questions. But right after you submit the application with Department of Labor, you're going to get an email confirming your intent to file this application. So you have to respond to the email within 7 days or the case will be denied. A lot of times these end up in spam, so you want to double check that. So you're going to be asked, are you or do you work for the employer referenced above? So that would be the person that's signing off on this application. Are you aware that an application has been filed? Do you have an opening for the job? Are you sponsoring the particular name of the person? And so all of those questions you're going to answer yes. And then after you submit that, then they continue processing. You do have to maintain all of your records of recruitment in your file for 5 years. That would be the prevailing wage determination, all advertising, any resumes received, recruitment report, proof of the foreign nationals qualifications, any business necessity documentation if you did get an audit, and proof that you've contacted laid off workers in that same position. So again, Department of Labor will certify, audit, or deny a perm application. There's no notice of finding or request for evidence. It's either all or nothing. The only way to correct errors on an application is to withdraw and refile. Any data entry errors or inconsistent answers are discovered automatically and result in denial. So the application is very finicky, so it requires attention to detail. Most cases are processed again in 6 to 8 months at this DOL stage. All right, again, if there's an audit, it can be random or for cause. Some of the causes would be if you're requiring a foreign language requirement, which we would never do. It just creates a lot of complication. If you're filing H2A applications for the same position as the green card, again, we need to explain how they're distinct and why you need a year-round role. Job duties or requirements that include multiple occupations. Roving employees, off-site placement. So if you have workers assigned to other employer addresses, that's going to be uncommon in this industry. But so there can be any number of these reasons that could trigger an audit. This we pretty much covered. All right, so the final phases of processing, phases 2 and 3. Again, after Department of Labor issues the labor certification, you're then going to file the I-140 immigrant visa petition and I-45 application to adjust status with USCIS. Again, filing fees, $700 for the I-140 per worker, and then $1,225 for the I-45 application. These are just filing fees, does not include any other costs for preparing the application. USCIS processing. So eventually, towards the end stage of the process, the worker is going to be scheduled for an in-person interview at the U.S. consulate, or sorry, the USCIS office in their area of residence. So wherever they're working, whatever your local office is, they'll have an appointment notice to appear there. A decision on the green card will be made at the interview. So the office is going to ask them questions about their role, their status, their prior history, and then make a decision. If approved, permanent resident card will arrive in 2 weeks. So that was basically a very quick overview of the process, and there are different nuances that could apply to various situations, but this is a general overview in most cases of how the process will work. And and I think we've seen some very good results, and things have been pretty streamlined for this process. The goal again is to kind of minimize some of the disruption of the H2 programs, H2A and H2B, in order to provide a longer-term alternative. So it may not work for everybody if you don't have a need for year-round workers, but it certainly is going to be an option for those employers that want to make that investment in having year-round permanent workers in the U.S.
Great. Thank you so much, LJ, for presenting a rather complicated topic and making it understandable. We do have a number of questions, and there's a couple more that have just come in, so we'll get to as many as we can before the top of the hour. So one question, a couple questions came in that I think you kind of addressed in your topic, and one was basically they relate to each other. They were the worker paying the cost of obtaining the green card, and then what assurance do you have that the employee will remain with you?
Right. Yeah. So we basically, again, the cost is a consideration. From my experience, the workers don't have thousands of dollars to cough up front to file an application. So in most cases, you'll at least have to front that money to them. Or if you're able to, to pay the cost yourself, you can protect yourself by having a green card sponsorship agreement. And I do these for our employers all the time, where you basically have them sign an agreement saying, if you're paying for any of these discretionary costs, that they will have to pay you back if they leave before 3 to 5 years from getting their green card. And it tends to be an effective tool to sort of not only make the worker understand the consequences of leaving, but also to protect the employer.
Okay, good. Are there any limits or quotas or like a national cap on the number of green cards issued this way?
There are a set number of green cards available for various categories. We have family-based green cards. We have 5 different employment-based green card categories. So we're looking at, not to make things ultra complicated, but this category falls under what we call a third preference category, employment-based third category. And when the visa numbers are oversubscribed, so if the government receives more applications for green cards than are available, then backlogs build. For the past couple years, they have not received that number of green cards for this category, so there have been no backlogs. So unlike H2B, for example, where if they're highly competitive, highly limited, we don't see that same issue here. So that's easily managed, and before you start the process, you'll be able to identify whether there's going to be an issue with an oversubscription of visas. But for the past couple of years, that hasn't been a problem. Okay,
thank you. Another question came in about workers either who have received the green card or are in process of adjusting status. Can they go back to their home country for a period of time, or is there like a minimum number of days they have to spend in the United States or something like that?
Nope, they can leave once, so they can travel through the Department of Labor process for stage 1 as much as they want, as long as they have a visa, an H2 visa to come back and forth. They have to be physically present in the US at the time we file the second and third stages, because that's the stage where we file their work permit and that. So they do need to stay here at that point until the travel document and work permit are approved, which could be 4 to 6 months. So for that period, they have to stay here. Once the travel document is approved, then they can travel as much as they want. They can be out. They just have to be here for when they're scheduled for the interview. They should be back for the interview. They'll have probably 30 days notice of that anyway. But with the exception of that one chunk of time of about 4 to 6 months, they can travel.
Okay. A couple of questions about employees who may have not completely clean records, if you will. So one is about an employee who was here and had a either misdemeanor charge or traffic violations or things like that that may have caused them to have trouble getting an H2A visa approved. Should they not bother with this process? I mean, how stringent are the background check requirements, I guess?
Yeah, so for the green card, it's not as stringent. So really, to make someone inadmissible for a green card, it has to be an intent crime, which is pretty serious. So if they had a traffic violation or a misdemeanor, it's unlikely to really impact the ability to get a green card. It has to be something really bad, like rape, murder, burglary, something that shows someone had to think about doing it, which shows that they're a bad person, that have bad moral character. But, if there are other reasons, I think the bigger issues are going to be status violations. If they were here illegally in the past, those are the issues that are going to come up that could trigger problems for the green card.
So, segueing into that, what about a worker who either is currently here undocumented or has been undocumented in the past? Is there a way for them to gain legal status somehow or through this program?
Those are the much more challenging programs or issues. Now, for family-based green card processes, there are certain waivers that are available. You can show extreme hardship to a U.S. citizen relative to get a waiver. For the employment-based categories, there really isn't a waiver like that. So anybody that's been here and triggered a bar. So normally what happens is if someone's been here illegally for over 6 months, you know, they trigger a 3-year bar from coming back in. If they've been here for over a year, they trigger a 10-year bar. So in order to get the green card, they would have to satisfy that bar. So that means, you know, they'd have to show that they were outside the U.S. for whatever that period would be, whether it's 3 or 10. If they have satisfied that, then the fact that they were here illegally in the past won't be a factor anymore. It's only if someone's within that statutory bar period that it affect the green card. But there really aren't any waivers to overcome that.
Okay, thank you. We had a couple questions relating to workers' families. If a worker has a spouse or dependents, how would they be able to come to the U.S. if they got a green card through this program?
So there are family-based green card processes. So the first thing would be, you know, the worker would probably change to, so if the workers could include their family members in the application if they're here. The problem is getting them here legally. So if they're able to, the family members are able to come in on an H4 visa, which is the derivative dependent visa to the H2. It depends on the consulate. Mexico has done that. Guatemala tends to be a little more strict, but it's possible that they may be able to come in on an H4 visa and just be included in that last stage of the application. They all process together, get their green cards together. If they're unable to get here, then they would have to be a dependent at the U.S. consulate. So yes, it is possible they can be included in the green card process. There may be a little bit more of a waiting period, but they can certainly tag along with the employee on their green card.
Okay. Wait, we're getting a lot of good questions actually. One relates to with H2A, the job descriptions are very specific. You can't really have your workers do things that are not in the initial job description or change it once they're here. Is that the case with this program? Does the worker have to remain in the same position as applied for, or could they transition to another position within the same employer, or I guess even for another employer?
Yeah, the timing depends on the timing. So while the green card's in process, we kind of want to have them be performing duties that are related to what was in the green card application, but it's not nearly as strict as H2A. So even if you did like a general farm worker, they could milk cows. You know, that's fine. It's not that strict standard. Now, after the green card's approved, there are 0 restrictions. They can work at McDonald's if they want to, even though you sponsored the green card. You can have them perform any role you want. There's no wage requirements at that point at all. So, you know, if you maybe when you started this process, you thought you needed them in a specific position, but when they got the green card, it turns out maybe you need them doing this other role. Well, you have the flexibility to reassign that role. And at that point, you know, really the prevailing wage requirements don't apply to somebody after they get their green card. I recommend honoring that prevailing wage rate for a while after they get the green card, but, you know, say after a few months, you know, you want them to perform a different role, well, you can recharacterize the position and pay them, you know, as long as it complies with, you know, normal wage an hour, Department of Labor minimum wages, then you're fine.
Okay. Another question that we had is, you went through the filing fees that add up and are fairly substantial for U.S. immigration. But what should an employer budget for like legal preparation for these things if they were to hire an attorney to do the work?
Yeah, that's more difficult to answer because people's rates are going to wildly vary. But I will give you an example. I find that the employers that have multiple workers together, there are some economies of scale. So if let's say, for example, I charge, it's broken down based on state. So if I charge, let's say, $2,000 for the Department of Labor phase, but you're going to have 10 workers or 5 workers. Well, that can probably be discounted because you're doing multiple workers for the same position. So it could be, $1,500 per worker for that stage. The other stages, the I-140 and I-485, generally I would estimate for, let's say, stage 2 I-140, maybe $1,500 per worker. The last stage, I-485, maybe another $1,500 as an estimate per worker. So I think if you plan on, let's say, $2,000 per worker at Department of Labor, I think multiple workers, it's definitely going to be less than that. It could be anywhere from $1,300 to $1,500 with multiple workers. I-140, say $1,500 per worker, and I-485, $1,500 per worker. That would be a good ballpark to estimate.
Okay, and without getting into too specifics here, about how many workers have you been successful with taking through this process?
So we've done both H2B employers and H2A, and the issues are the same for both. They're very similar. One's just limited to ag, one's not. We had one company last year that was one of the first companies that we did a wide-scale program for that was on H2. They filed for 17 workers, and every single one of them was approved. And we just got through the last one earlier this year. And it, quite honestly, has completely transformed the entire employer workspace because they no longer need the H2B program. They haven't filed for it for the past 2 years. So when you think about cost, think about the savings that by not participating in the H2 program. Unless you want to maintain both programs, that's fine. But this particular company didn't have the need for it because they processed 17 workers who were grateful and loyal and continue working. We're working with many farms right now in various stages. With landscape companies, we're doing a lot with. So far, we've had no issues through it. And it's a matter of timing things correctly and making sure that everything's done, the forms are prepared correctly. We're identifying the position and why it's permanent. But so far, we haven't experienced any challenges or any difficulty in the program.
Okay, that pretty much brings us to the end of our questions, and we're getting close to the top of the hour here. So do you have any final thoughts or comments, LJ?
No, it can be overwhelming. There's a lot of information that is thrown at you, and there's a lot to digest. So, what I would recommend is if you have specific questions or, are interested in the program, I'm always happy to answer questions. My contact information or emails on the presentation. So I'm happy to answer general questions to see if your positions qualify or see if it's something that is even an option for you.
Okay, great. Well, on behalf of Farm Credit East and the New York Farm Bureau, I thank you very much for your time and this great information, and we will adjourn.